justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule at the defense rests.
She testified, called herself as a witness in that hearing on July 12th. Her testimony was inconsistent internally. Her testimony also conflicted with at least one other witness. Now, we have since supplied this court with affidavits from her former co-counsel, Erlinda Johnson, to highlight additional, we believe, false testimony that Ms. Morrissey gave to the court. Now, that's important because I think this court has to view through the prism of the prior findings of the affidavits, the comments Ms. Morrissey is making, and what I consider to be shade on the truth on her statements. Now, part of the court's findings at paragraph 10 in Baldwin's case included that the state had continuously made late disclosures and that the state had filed a certification, specifically Ms. Morrissey had certified that she had supplied all of the evidence required under the rules under 5-501. Now, that same thing occurred in this case. And Your Honor, post-trial, we have now learned that Ms. Morrissey never disclosed to us, and I'm going to get into these and why they're important, the Hague report from August 31st, the Seth Kinney interview that I've highlighted in the motion, and the third one are these Teskey rounds. And I'm going to explain that in a little more detail as well. Now, the same thing the court found in paragraph 10 applies here. The state made that certification and it was untrue. Your Honor also found in paragraphs 27 and 28 that officer that CST Popple that testified in Ms. Gutierrez-Reed trial had lied, had given false testimony in Baldwin's trial. Specifically, there was a interchange between Ms. Morrissey and Ms. Popple, in which the idea came up in testimony before the jury that these rounds were not similar. The Teskey rounds were not similar to the rounds found in the rest set. The court then held a hearing on July 12th and actually ordered those rounds produced. And despite Ms. Morrissey's continued assertions to me, to the jury, and also part of her testimony that they were not similar, there were three very similar or identical rounds, Starline brass, with silver primers. Now, as part of that aftermath, Corporal Hancock testified that Ms. Morrissey was part of the meeting to what I consider to be bury and hide the Teskey rounds that were turned in on March 6th in a separate case file under a separate number. Now, Ms. Morrissey stated that the first time she saw these rounds was July 12th. Then the court asked a question during that hearing to Corporal Hancock. Corporal, was Ms. Morrissey present in the meeting to put those rounds in a different case file under a different number? And she said, yes, she was. Well, and that's part of the court's findings in this court's order, that Ms. Morrissey was part of the decision to hide those rounds, hide the supplemental report, and to not have that produced. Now, in Mr. Baldwin's case, the standard, and as this court notes in paragraph 48, was evidence disclosed within a trial. Ours is obviously the standard post-trial. And so this court delineates that standard and how it's different for post-trial discovery of evidence. Now, that is that we have to show that there was a reasonable probability that the outcome would be different. And I'm going to get into that with each of our pieces of evidence. Judge, the fact of the matter is, we would have never discovered the Teskey supplemental report or what they had done with that if Baldwin's case had not occurred, if they had not done those interviews. We would have also not discovered the Hague August 31st report, because those came out in Baldwin's interviews in that subsequent case. Those were never turned over, as was Seth Kinney's. So they were all suppressed. Now, were they favorable? The court finds, as part of its order in the July 31st order, that there the defense had outlined a progressive trail of how the rounds got from Troy Teskey to the set of rust. And that was in paragraph 30 of this court's order. The court went through how they went from Teskey to Seth Kinney. They went to the 1883 set and how they ended up on October 12th being given to Sarah Zachary. Now, the court also said that any additional information as to the source of live rounds or how they arrived on set would likely affect the jury's determination as to proximate cause and as to negligence of third parties under 14-251 UJI. Now, it is the same thing in Ms. Gutierrez-Reed's case, but the facts are different. The reason why the facts are different are that Ms. Morrissey, in effect, suppressed them in our case by telling Mr. Teskey she would retrieve these. She told him in his pretrial interview, and that's detailed in our motion, that she would retrieve these and the state was going to collect them. Now, that never happened. But by telling Mr. Teskey that, Mr. Teskey didn't want to do anything with those rounds. He didn't want to touch them, and he wanted to keep them secure and safe. Now, I was not able to see those rounds until the second to last day of trial was the first time I saw them. Mr. Teskey didn't want to bring them. He didn't want to be accused of tampering or obstruction, and I didn't want to, and Ms. Morrissey said I didn't want the evidence. She, again, shades the truth. The fact of the matter is I didn't want to be in the chain of custody, nor did I want there to be any allegation that I had anything to do with something nefarious with regard to those rounds. So I directed Troy Teskey to turn those in to the sheriff, which he did, because we wanted law enforcement to have them, because I thought naively the state would do the right thing and would test them. Never in a million years did I think the state was going to hide those in a separate file under a separate case number, which then came out on the Baldwin trial. So that's what Mr. Teskey did. He turned those into the state. In the aftermath of that, we weren't told what happened. We weren't told there was a separate file. We weren't told any of that. Because Ms. Morrissey basically held those in place with Mr. Teskey, it's the same thing as the court found in the Baldwin case. We weren't able to test those. We weren't able to utilize those rounds. We weren't able to even touch them because the state was going to seize them. Now, had we been able to use them, it goes back to the court's paragraph 30 on outlining the trail of how the live rounds got on set and how they got in the hands of Mr. Kinney and got to Rust. The state's theory at trial against Ms. Gutierrez-Reed was based on a series of pictures that they put together that Ms. Gutierrez-Reed must have introduced the live rounds because here's the pictures. Well, in reality, now that we learn that Mr. Kinney could have introduced those on October 12th through Sarah Zachary, and the jury could have been shown and seen those rounds. I asked the state repeatedly to test them, and they would not. Even though they tested every other piece of evidence in this case, except the live rounds, they didn't test those for DNA and fingerprints, but they didn't test the Teskey rounds. They refused to. Your Honor, second, as to the Hague report, I think this is very critical. The Hague report and the one we're talking about, this is one that we never got during trial. Mr. Hague, the state's chief expert as to the firearms, made a report that says it seems unlikely, although it cannot be excluded, that these tool marks on the firearm are the result of the damage incurred during the FBI's impact testing. He goes on to say that they do not appear to be original manufacturing marks or use and abuse tool marks. Now then he follows with these tool marks are unlikely to have had any bearing on the operation of the revolver at the time of the incident based on the FBI's trigger pull data. However, the fact that he made the comments that they seem unlikely to have occurred during the FBI's impact testing and not consistent with original markings, we could have used that at the trial. And in fact, Your Honor, what's even more important is I asked Mr. Hague on the stand a very open-ended question. My question was, did you see any other evidence of modification or damage to that firearm other than what the FBI's testing did? He said, no, sir. Now, Ms. Morrissey tries to again spin that by saying that was in the context of the functionality of the firearm. I did not include the word functionality in that question. It was a very open-ended question. Mr. Hague said, no, sir. when in reality, both Miss Morrissey and Mr. Haig knew at that time he had authored a report that showing that there was other damage to the trigger and to the sear. Now, later on, Miss Morrissey points out in a response, after Hannah's trial, Mr. Haig is able to learn more about the firearm, and then he's able to change his conclusion. But at the time of the trial, Mr. Haig had a report saying there were unexplained tool marks and on the trigger and sear, and they weren't explained by the FBI's testing or the original manufacturer. Your Honor, we would have used that in the questioning and potentially raised an issue in the jury's mind regarding that jury instruction 14251, which is critical in this case. The jury sent out a question on that jury instruction. And that is, was this an uninterrupted chain of events? Or did something occur that interrupted the chain of events that would have been a proximate cause issue? If there was damage to the trigger or sear, and we're able to cross-examine Mr. Haig on that, the jury doesn't have to believe his conclusion that this didn't affect the functionality. They don't have to believe that. And again, this goes back to Ms. Morrissey, who stated to this court repeatedly, certain items of evidence are not relevant. And it's her determination she did things because they're not relevant. But that's not her call. That's not her call under the standard, under Brady and under exculpatory evidence, because the defense may have a different use for them. I guarantee I would have altered my strategy at trial, as the court said in the Allison case. And that case is where the court reversed a conviction of a defendant's arrest record that wasn't disclosed to him. Obviously, he knew about that arrest record, but the court said it could have altered strategy of the defense at trial had we known about it. They were going to use it. Well, the same thing is here. If I had known about that report, we would have highlighted that, and we would have made a strong argument under 14251. You can't be sure as jurors that this didn't affect it because we have a report here showing from Mr. Haig there was damage that he can't explain. And he was a very important witness in this case. It's inexplicable that we didn't have this report. And Miss Morrissey this trial ended March 6th. It was August 31st that Miss Morrissey first indicated in an email that this report would be turned over, and it was her failure why it didn't get turned over. There wasn't a very good explanation. There is no good explanation for not turning that report over that we could have made use of. The other thing that's critical to understand is this was coming out during the Baldwin interviews, which was going on simultaneously as we were having our trial. So it's just inexplicable that Miss Morrissey would have hidden this evidence for use in our trial. And Your Honor, finally, the Seth Kenney interview, that interview had several things, and this interview was suppressed. I would have crossed him on several of the statements. Now, Miss Morrissey's comment is that we knew about these other items through other witnesses. That's kind of the general statement she's made in response. The facts of the matter, however, is that Miss Morrissey vouched for Mr. Kenney improperly in closing argument, saying he was, in essence, anybody that disagreed with what he said was lying, and basically that Mr. Kenney was telling the truth. So it would have been very effective for us to be able at trial to have used Mr. Kenney's own words in this interview that we did not get to cross him on statements he had made. So that is the import of that as to impeachment. These items are material, they are favorable, and Your Honor, I think the most significant thing that came out of the Baldwin hearing, and this court appropriately and was warranted dismissed that case with prejudice because of the egregious and continuing pattern of discovering misconduct. And it didn't just start after Hannah Gutierrez-Reed's case. That's not, they didn't conduct themselves ethically and then all of a sudden unethically in that case. This pattern of discovery abuse occurred in Ms. Gutierrez-Reed's case in the same manner as it did in Mr. Baldwin's case. And because of that, we are asking the court to consider dismissal in this court's inherent power, and the court lays out in its order the court's inherent power to issue a whole host of sanctions, or in the alternative, a new trial, Your Honor, because it's the significance of the items that were suppressed, favorable and material to Ms. Gutierrez-Reed that could have been used. We also have a situation, Your Honor, where I'm going to ask the court to order in this court's inherent power, if this court orders a new trial, to remove Ms. Morrissey as special prosecutor. She has testified before this court, and I submit, and I don't do it lightly, her testimony was false in several material aspects. This court's findings in its order indicate that at the very least, she didn't exercise reasonable diligence to ascertain the nature of those Teskey rounds, because she was at that March 6th meeting. But I would say at the worst, because she did know that there was 3 silver primer rounds before July 12th. And so, Your Honor, I'm asking that this court, in its inherent power, remove her from further prosecution of the Rust case. And we are asking for a dismissal on the same basis as this court dismissed Mr. Baldwin's case.
All right, thank you. Response?
Initially, I want to just ask, Mr. Bowles indicated that there was an affidavit provided by Ms. Johnson. I don't have that. I haven't seen it attached to any of the pleadings, so I'm not sure what he's referring to. So if obviously he mentioned it, can I get some insight into when that was provided?
Your Honor, I will try to locate this in the pleadings, but there was an affidavit filed with that's in the court record in the recent Baldwin response. But I think I've attached one in this case as well. I just would have to find it.
Well, is it in here? When did you file it?
Judge, I thought I filed it with our motion, our reply to dismiss, but I'm not seeing it right away. The motions I printed out don't have the exhibits, Your Honor, so I'm not seeing it.
Well, I just went through every motion that's on Odyssey that has the exhibits attached, and it's not there. So.
All right, if you can't produce it, I'm going to strike that part of the argument regarding Ms. Johnson.
Yes, Your Honor, and I would just say that part of the court record in the Baldwin case is that there is one filed in the recent response. Mr. Nika's filed.
But it's not in this case.
Yes, I can't find it readily, Your Honor.
Okay, so I'll strike that part. Go ahead, Ms. Morrissey.
I will say, though, that this is an issue that Mr. Bowles raised in his initial motion for a new trial. I responded to it. I stand by my response. I summarized the conversation that I had with Ms. Johnson, and Ms. Johnson indicated that she wanted the case dismissed out of issues that she was concerned about for self-preservation. I disagreed with that. I don't think self-preservation is a reason that you dismiss a case. There's a legal analysis that has to be done in order for the court to consider disqualifying a prosecutor. Mr. Bowles hasn't cited to any of those cases, and he hasn't put that legal analysis in any of his motions. So I would ask the court certainly not to consider granting that without a motion that actually addresses the law and the facts as they relate to the law. This isn't something that you just randomly ask for. The legal analysis has to be conducted, and it hasn't been conducted here. So having said that, I responded to Mr. Bowles's concerns about the veracity of my testimony. Quite frankly, I'm not sure that it's relevant to his motion for a new trial, but because it's something that he's put in his motion and it's something that he has argued, there was no meeting about these Teskey rounds. I did not attend a meeting. I did not see the rounds until July 12th. I did not see the doc report until I believe it was July 12th or July 11th. I'd have to check my email. Whenever I got it, and I provided it to the defense attorneys. I had no idea that there were 3 rounds that had the same characteristics as the live rounds from the set of Rust until July 12th. Mr. Bowles can complain all day long that he thinks that's not true. I'm telling you it's true. And how that ended up happening is actually quite clear, because what happened in this case is that Mr. Teskey took a photograph of the rounds that he had in his possession and he sent it to Seth Kinney. We ended up with that photograph. I've included that photograph in my response to this, to Mr. Bowles' motion for a new trial. It does not show any ammunition that looks remotely similar to the live rounds that were found on the set of Rust. He went further than that. Mr. Teskey said, I looked at these rounds, I couldn't find any with silver primers. Okay, so at this point in time, the state, this is long before I ever came on the case, but the state understands at that point that the ammunition that he is in possession of does not look remotely similar to the live rounds on the set of Rust. That doesn't make them material. It's okay for us to say we're not going to collect those because he sent pictures and they're not material. Then we go ahead and we do his pretrial interview. And I decide maybe I should go ahead and collect those. So I make that statement to him during the pretrial interview. Mr. Bowles can argue all he wants that he was assuming that we were going to take him. He had no idea that we weren't going to collect him. I had an email exchange with him in January that's attached to my response where I explained to Mr. Bowles, I am not collecting that ammunition. If you want it collected and you want it tested, go ahead and do it and ask for a continuance of the trial. That is a conversation that took place over email and it is attached to my response. So Mr. Bowles understood we were not going to collect it. And it was during that email exchange that Mr. Bowles then provided more photos of the Teskey ammunition. And those photos matched exactly the photos that were provided to Mr. Kinney by Mr. Teskey, and they showed rounds that were completely dissimilar to the live rounds on the set of Rust. This is information that is coming from Mr. Teskey, and it's filtering through Mr. Bowles. So Mr. Bowles doesn't get to come to the court now and say, hey, they should have collected these. The information that he gave us caused us to reasonably believe that they were completely immaterial. We had no idea that any of those rounds matched the live rounds from the set of Rust. Mr. Bowles provided us a photograph in January, a month before the trial, for heaven's sakes, that showed that they were completely dissimilar. So then let's jump to the trial. This is where Mr. Bowles' argument completely fails. He wants to rely on the court's dismissal of the Baldwin case, but he can't rely on that because what happened was these rounds were in the possession of his witness. He told his witness to bring them to court. He got to look at them. He told his witness, I'm not going to call you as a witness, and I'm not going to take these rounds. We're not going to touch any of this. I understand why he did it. Because, again, as I have said, sure, in a world of infinite possibilities, can you argue that these rounds somehow came on through Seth Kinney? I guess, but you can certainly you have a much stronger argument that this is how they came on through Ms. Gutierrez. Her father had these rounds that were exactly like the rounds that she brought on. So Mr. Bowles knew about this during trial. So when we're doing the legal analysis for whether or not Ms. Gutierrez gets a new trial, she does not get a new trial based on this ammunition that was in the possession of her father's good friend and that she and her lawyer had during trial. The state did not have. She and her lawyer had them during trial and chose not to use them. That is exactly what happened. So the legal analysis, the 6 factors that this court has to look at when deciding to grant a new trial, the second one is that the newly discovered evidence has to be discovered after trial. That's not the case here. This evidence was discovered by Mr. Bowles during her trial when the state had no idea what those rounds were comprised of. He made the judgment call, hopefully after consulting with his client, not to call Mr. Teskey and not to use the rounds. They don't get to now come and say, we made a strategic error, so give us a new trial. That's not how this works. So the issue of the Teskey rounds with regard to Ms. Gutierrez's motion for a new trial, it is absolutely, it's not permitted under the law. It was not discovered after trial. Here's the other thing that the court needs to take into consideration. A motion for a new trial can be filed for almost any reason within 10 days of the conviction. Mr. Bowles is limited to a motion for a new trial based on newly discovered evidence beyond the 10 days. So Mr. Bowles, having seen those rounds for himself on the second to last day of trial, having infinitely more information about those rounds than I had, easily could have filed a motion for a new trial within the 10 days, but he chose not to do that. So he has given up, he has waived his right to use that in a motion for a new trial. Furthermore, I want to point out to the court, Mr. Bowles filed a lengthy motion for a new trial, and never once did he articulate or argue the legal standard that is required for a new trial. Never one time. And I'm glad that Ms. Gutierrez is listening to this, because the legal standard that he is required to meet was never mentioned one time during his motion. The state mentioned it in the state's response because these are the 6 factors that the defendant has to meet in order to get a new trial. So let's move on to the Kinney interview. Mr. Bowles outlined, I think, approximately 20 statements in that interview that he had specific concerns about. And he's absolutely right. I want you to know this was suppressed. The moment that I found out that this audio recording existed at the district attorney's office, I immediately provided this to Mr. Bowles. I couldn't believe that there was an audio recorded interview of this witness that had been sitting at the district attorney's office that had never been uploaded to the discovery server. The previous prosecutors were unaware of it. I was unaware of it. My team was unaware of it. It was absolutely a failure. There's no question about it. I immediately provided it to Mr. Bowles. But that's not the end of the analysis. The analysis is Mr. Bowles has to meet those 6 factors in order to get a new trial. So what Mr. Bowles did was he filed a motion and he outlined 20 statements, the vast majority of which were statements previously made by Mr. Kinney that were already in the possession of Mr. Bowles and Ms. Gutierrez. So then when we get to Mr. Bowles's reply, what we see in the reply is that the 20 statements have now basically been narrowed down to 5, because someone had to come and point out that Mr. Kinney had already talked about the fact that there were 325 rounds that were taken to Texas. He had already made all of those statements about Sarah Zachary being the boss. He'd already made all of these things. So Mr. Bowles filed this motion, having seemingly not reviewed any of the discovery that was in his possession with regard to Mr. Kinney's statements, so that he could file a motion that actually had the material issues related to the Kinney interview. So now we're down to the 5 issues that Mr. Bowles ends up relying on, because the other 15 turned out to be things that really were already in his possession, were already within his knowledge. So when we go through and we look at these, I'm sorry, there's I think he narrowed it down to 8. So where he is right now is he's asking the court to grant a new trial because the interview with Mr. Kinney talked about that there was a standard that Ms. Zachary was the boss and she's managing things, which allows the armorer to focus on guns. This came out during trial. Not only did it come out during trial, it was fully articulated in the text messages between Mr. Kinney, Ms. Zachary, and Ms. Gutierrez. Hannah has more experience on Westerns than Mr. Kinney did until 1883. Well, I would hope so, because Mr. Kinney is not an armorer. So the comparison between Ms. Gutierrez's experience and Mr. Kinney's experience has absolutely nothing to do, is completely immaterial with regard to this case. And importantly, the factors that this court is required to consider do not create a situation where Mr. Bowles gets a new trial because there's something out there that could be potentially impeaching. The law actually doesn't give him that with regard to a new trial. His third issue, prop masters who handle guns won't call out armorers to test bullets. I don't understand. I mean, I don't understand how that could even be remotely material. We had plenty of evidence from people who were on the set, who work on movie sets. Mr. Kinney does not, by the way. He doesn't work on movie sets. And we had an expert come in and say that armorers are supposed to test the bullets. So how is this material? The sheriffs confuse the replica guns with the real guns. What does that have to do with the elements of the offenses that Ms. Gutierrez was charged with? It has absolutely nothing to do with those. Mr. Kinney heard nothing but good things about Hannah on set, and all of the concerns about safety that came out later he hadn't heard about. Judge, that's all in the text messages that Mr. Bowles had. He had all of that. Mr. Kinney actually, there's an exchange between Mr. Kinney and Ms. Gutierrez where she talks about the director saying what a good job she was doing, and Mr. Kinney responds. All of that is in the text messages. This was always in Mr. Bowles's possession. Mr. Bowles didn't review it. He didn't use it during the trial. That was his decision. Sabotage could be anyone on set. Mr. Kinney doesn't work on movie sets, and he was never on the set of Rust. Okay, so this is his speculative opinion. It was also something that Mr. Bowles had the opportunity to fully explore at trial, and did in fact fully explore at trial. Because Ms. Gutierrez left the ammunition unattended, anyone could have messed with it. Yes, we went through all of that. Because these firearms were left unattended, yes, anyone could have messed with them. We knew all of that. All of that came out during trial. The idea that if the camera crew had gotten their hotels, would they have still felt unsafe? This is number 7 in Mr. Bowles's reply. This has absolutely no material value with regard to the case against Ms. Gutierrez in any way, shape, or form. That the assistant director and Alec Baldwin didn't give Hannah every ounce of support and she got pushed around. Well, this was Mr. Kinney's opinion, but you also have to keep in mind, Mr. Kinney was never on the set of Rust. Mr. Kinney never met Mr. Halls, the assistant director. He also never met Alec Baldwin. So this is a statement that he made that has absolutely no foundation and also is completely immaterial to the case against Ms. Gutierrez. Now, we get into the issue of the third Hague report. And look, I understand that to a certain degree, the job of a defense attorney is to make things seem perhaps a little worse than they are because it helps their arguments. Nothing was intentionally buried. This case had a terabyte of discovery. There was new discovery coming in constantly. This was a report that I believed I had forwarded on to our staff to have it uploaded to the server. When I realized during the Baldwin preparation for trial that did not occur, I immediately I took full responsibility for it. Mr. Bowles points to the email where I took full responsibility for it as though I've done something wrong by taking responsibility for it. I believed that it had been forwarded on. I went back, I looked, it had not been. We did the best that we could to resolve it at that point in time. And listen, the problem with Mr. Bowles' argument with regard to the Hague report is twofold. First of all, the Hague report clearly says the microscopic marks on the tip of the sear did not affect the functionality of the gun. Furthermore, Mr. Hague has since learned exactly how the destructive testing of the gun was being done and has now come to the opinion that these microscopic marks were made by the testing at the FBI. So Mr. Bowles wants to say, Judge, it doesn't matter. The fact that the guy has changed his opinion after he got new evidence, that stuff shouldn't matter. Well, it most certainly does matter, because when you look at the 6 factors that this court has to consider when granting a new trial, is the probability that the result would be different if the new trial was granted. So if you have an expert who said, initially, I'm not exactly sure where these microscopic marks came from, but I don't think that they came from the FBI. Then he goes and he talks to the guy at the FBI, gets more information about how that testing was done, and the expert then says, okay, now that I've got this new information, I've changed my opinion. I think that they did come from the FBI. Well, that goes directly to the first prong of the 6 prongs, which is whether or not a new trial would result in an acquittal if the court were to grant the motion. It's not going to, because Mr. Hague got more information about the testing, modified his opinion, and the other thing is that Mr. Bowles hired, although I don't think he paid him, but he had his own firearms expert. Not only did he have his own firearms expert, he used an investigator in this case who purports to have a fair amount of expertise in firearms. So you've got basically 2 people who have expertise in firearms working for the defense, and you have the photos of the sear and the microscopic markings on the sear that were provided to the defense for their review. Not only did they have the photos, but the gun was sitting over in evidence. They can go, they can look at the gun, they can take the gun, they can test the gun, they can do any of those things, and they opted not to do any of them. Now, presumably, either the defense expert, Mr. Kuski, or the defense investigator was tasked with going through all of the photographs that Mr. Hague took. What Mr. Bowles has actually said in his reply is, oh my gosh, Judge, there were so many photographs. We can't be responsible for having to review all of those. They certainly can be. They needed to review each and every photograph. I know how long that takes because I did it myself. So the basis of the Hague opinion was always in the possession of the defense. And they seem to just basically ignore the fact that they had the photos, that they had their own expert, and they basically had their own expert come in and say, we agree with Mr. Hague, the gun worked fine. That was the reason that they called that expert, was just simply to say, we agree, the gun worked fine. They had everything that they needed. But listen, I'm not trying to take away from the fact that this was a report that should have been provided and wasn't provided. I have taken full responsibility for it. I will continue to take full responsibility for it. So I want the court to know I'm not trying to get around that. But one of the factors that this court has to consider is, would the newly discovered evidence have been discovered before trial by the exercise of due diligence? They had a photograph of it. They had a photograph of the markings on the sear, and not only was it a photograph, right next to it is a photograph of a sear without those markings. It was in the possession of the defense the entire time. So this easily could have been discovered by due diligence. That due diligence meaning simply go through the discovery that you have. Go through the discovery that you have. And you know, New Mexico is unlike so many other states, in fact, perhaps all states, because defense attorneys actually get to interview the state's witnesses. So that is the opportunity for the defense to exercise their due diligence to discover things. That's the whole point to the pretrial interviews. So in this case, what happened was, we had a pretrial interview scheduled of Mr. Haig. Mr. Bowles did not attend, because Mr. Bowles did not attend, I think, 95% of the pretrial interviews. So he opted not to attend. He left it to his investigator. His investigator conducted a 25-minute pretrial interview, and not a single question was asked by the defense investigator about any of the photographs that the Haigs took. They asked about the damage to the gun. Mr. Haig indicated there was damage to the gun. He further indicated that the sear was damaged. That came out in the pretrial interview. So when you look at the 6 factors that the court has to consider when granting a new trial, the defense doesn't get there. They simply do not get there. I further have some concerns for the record. So one of the issues that Mr. Bowles has made an issue in these motions, which is a little confusing to me, is the issue with regard to the standard of state v. Ware. So what he's arguing is that the ammunition that's in Teskey's possession, under Ware, the state had the obligation to go and collect, and by not collecting it, that resulted in a due process violation to his client. Here's the problem with that argument. I sat and went through every single New Mexico case related to Ware. I can give you the list, and for the record, because we have so many potential appellate issues, I'm going to tell you, Judge, not only did I look at State v. Ware, I looked at State v. Crone, which was provided by Mr. Bowles. I looked at State v. Kinney, State v. Torres, State v. Martinez, State v. Camden, State v. Rodriguez, State v. Bailon Escobedo, State v. Baca, State v. Garcia, State v. Kant, State v. Taylor, State v. Perkins. Those are the New Mexico cases that discuss the Ware standard. Every single one of these cases says that the obligation of the state has to do with collecting evidence from the crime scene, and they make it very, very specific. And Ware indicates this is very limited. The state is not required to scour the planet Earth for potentially exculpatory evidence. It is evidence that is from the crime scene. This is not evidence that was from the crime scene. This is evidence that was in the possession of a defense witness. Mr. Bowles knew in January that we weren't going to collect it. He knew that it had never been collected. He certainly did know that because he was in contact with Mr. Teskey. Mr. Bowles could have had that ammunition tested. I mean, the chain of custody was shot. There was never going to be any chain of custody with this anyway. This isn't something that was located at a crime scene and was taken into evidence. This is something that was sitting in a defense witness's garage. So Mr. Bowles could have had this tested. He opted not to have it tested. He could have had it tested. He could have had those test results compared with the test results of the FBI. And the best case scenario for the defendant is that would indicate that the same powder that was used in the ammunition that was in Teskey's possession is the same powder from the powder, or consistent rather, with the powder from the ammunition from the set of Rust. And that exact same powder is used in millions and millions of rounds of ammunition everywhere. One of my concerns since this issue arose has been the fact that Mr. Teskey 2 times sent photos of the ammunition in his possession, twice, and never sent a photograph of a round with a silver primer. In addition to that, he indicated, I have looked at these rounds and there are none with silver primers. And then 2.5 years later, he shows up with ammunition that looks just like the ammunition from the set of Rust. And again, you can buy this ammunition at any gun store. This isn't special. You can get it anywhere. You can get ammunition with these exact same characteristics at any gun store. So out of, to be thorough and complete, the where analysis doesn't match in this case. It absolutely is really irrelevant to this case, because the defense had more access to this ammunition than the state did prior to Ms. Gutierrez's trial. Now, with regard to the Baldwin case, that's a completely separate issue, because that is information that was in the state's possession prior to his trial. So there are real issues with regard to that disclosure. That's completely different. This case, Mr. Bowles had it in his hand. He had it in his hand during trial. And Mr. Teskey, I'm not making things up, Mr. Teskey told law enforcement on video, I offered this to Mr. Bowles and he said he didn't want it. That's what Teskey says on the video. So, you know, Mr. Bowles acts like I'm pulling this out of thin air. I'm not. That's what Teskey said. He said Bowles didn't want it. And again, Judge, I understand why he didn't. So I also want to articulate, because I think that this is an issue that Mr. Bowles is raising and is arguing, specifically with regard to the reply that he filed. And let me be specific in his reply, if you'll give me just one moment. I'm just reviewing my notes here real quick. So with regard to Mr. Bowles's reply, he says, both parties, the defense and the state, knew that Teskey had ammunition from the same batch that Reed and Kenny took to Texas. I disagree with this statement insofar as it oversimplifies what happened. So both parties knew that Thel Reed possessed a variety of .45 caliber ammunition with a whole lot of different characteristics. That was proven by the photographs. It was proven by the ammunition that was taken from PDQ into the sheriff's department. So, but what there's no proof of, absolutely no proof at all, is that each type of ammunition that was in Mr. Reed's possession went to Texas and then went to New Mexico. So if Mr. Reed has 20 different types of 45 caliber ammunition, and it strikes me that he had about 20 different types of 45 caliber ammunition, there's absolutely no evidence or testimony that the ammunition that is silver primer starline brass with that particular projectile shape ever went to Texas, let alone ever came to New Mexico. So when we say it came from the same batch, I guess my concern is, what do we mean by batch? If there is evidence, actual evidence, that these specific rounds went from Arizona to Texas to New Mexico, I've never heard it. Mr. Bowles actually went so far in his reply to say that the Teskey evidence was deliberately hidden from him. The Teskey evidence wasn't deliberately hidden from Mr. Bowles. It was provided to him by his own witness. He could have had it tested at any point in time. I would respectfully ask the court to deny Mr. Bowles' motion, and if Mr. Bowles wants to file a motion to disqualify me, he can file that motion. That is a separate motion. There is case law on that motion. I would ask the court to deny this motion. Thank you.
Thank you, Ms. Morrissey. Reply, Mr. Bowles.
Yes, Your Honor. Thank you. Your Honor, I want to start off by telling the court several initial points. The Teskey evidence that was deliberately withheld was the Teskey supplemental report. We still have Brady rights on appeal. That was not given to us, the March 6th report. So Ms. Morrissey misconstrued that. She also misconstrued the idea that I didn't want the evidence. What I told Mr. Teskey was that I didn't want to be in the chain of custody of those rounds. And I was actually a good idea that I did not, because Ms. Morrissey is now accusing Mr. Teskey, in essence, of planning silver primer rounds in that group of rounds. She just made that argument. Now, Mr. Teskey originally, way back when this case started, did a cursory search through the rounds and did not locate any silver primer rounds. He thereafter didn't touch them, and that's where the text came from very early on. He didn't touch them. Miss Morrissey was saying she's going to come get them. That's what she said at the interview. So by the time we had the email exchange, which, by the way, Your Honor, she didn't email me. I emailed Miss Morrissey trying to figure out where this was at. And then she responded, I'm not going to get these rounds. It was too late. This court had made clear, and I don't remember the exact date, but that we weren't going to continue the trial. There was not sufficient time at that point to test them. And we could not test them, Your Honor, because the FBI had the powder for the live rounds on set. We don't have an ability to match those unless they're tested at the FBI. So the state did suppress those. And we're not asking on the Ware standard for them to go to the ends of the earth, as Ms. Morrissey said. They knew the individual who had them. They knew this early on. And that, as the court put in paragraph 30 of the court's opinion from July 31st, there was a progressive trail established of how these rounds could have gotten to the rust set through Mr. Kinney. Now, Ms. Morrissey wants to denigrate that idea, but finally today she said, well, I guess in a wild speculation, you could say Mr. Kinney brought them. No, that's a real possibility. That's something the jury should have been able to consider, but they never wanted to acknowledge any possible defense theory, which is why they suppressed everything, because Ms. Morrissey didn't think it was relevant. With regard to the Hague report, Ms. Morrissey made extensive argument about how we should have divined these microscopic or very small damage to the trigger and sear through looking through thousands of pictures and having our experts somehow divine the opinion of Mr. Hague that this, or come to the same opinion as Mr. Hague. But what she's ignoring and trying to get this court to ignore is the failure to produce that report from the main state witness who was opining on whether the gun functioned correctly. And I just accepted that at trial because I accepted his answer that there was no modification that affected, and no modification other than the FBI testing, which that was the case in the pretrial interviews. That was the case at trial. Ms. Morrissey said pretrial interviews are where we can figure these things out. Well, we couldn't even figure out at trial because he didn't answer the question in a truthful manner. What he said was there is no other modification to that trigger or sear. Now that's false. And Ms. Morrissey wants to conveniently skip over that and the idea that we should have had this and it's no harm, no foul, even though we have abundant proof of false testimony, and she's admitted we didn't get the report. That's something we could have absolutely crossed on and used under 14-251 on this idea that the court pointed out in Mr. Baldwin's order on the negligence of third parties and the proximate cause argument. Your Honor, regarding the Seth Kinney statements, I did read it all. I boiled it down in the reply to the 8 most important, and that's why I wanted to get to the court to consider. Ms. Morrissey tries to, again, run away from the idea that she suppressed something by characterizing as we had it all. Well, we didn't have it all, and we didn't have it specifically all from Seth Kinney's mouth. So that's not true, the arguments that were just made, and we could have crossed him on that, and he was an important state witness, as this court knows. Your Honor, with regard to the Teskey rounds, what Ms. Morrissey didn't address at all is not the new trial grounds, but we've asked for a dismissal under the court's inherent power. And the whole Teskey argument, and I've been open about it, I didn't see those till 2 days before the end of the trial. At that time, there was no way to do anything with them because they had been suppressed in essence by the state not getting them, Mr. Teskey not wanting to touch them. For the exact reason that Ms. Morrissey accused him today of planning rounds. That's the reason why he didn't do anything with them. But Your Honor, the Teskey evidence and the court's opinion in Baldwin goes to the remedy of dismissal because the egregious nature of this prosecutorial misconduct in this case, specifically by Ms. Morrissey, her false testimony does a blow to the whole system of justice. It's not just to this case. As this court appropriately found and was warranted in Mr. Baldwin's trial, this affects the whole system. Why people respect the system, they voluntarily turn themselves into jail when a judge rules, is because they have respect and confidence and public trust. What Ms. Morrissey did in this case is she destroyed public trust across the board in the Rust prosecutions on a case that was watched by the nation and the world. A case being paid by the taxpayers, one of the biggest debacles, ethical misconduct, probably in the history of New Mexico. But this court appropriately dismissed that case to restore and maintain and uphold the integrity of our system. And so I'm asking the court to consider doing that in this case as well, because it's not fair and it's not right when the prosecutor doesn't play by the rules and it doesn't engage in fair play. That undermines our entire system.
All right, thank you for your presentations today on this particular motion. I will consider these arguments as well as the pleadings. I will issue an order. I plan to issue the order early next week. All right, but at least next week. All right, let's move on to the motion for immediate release.
Yes, Your Honor, and that really, I think, is predicated upon the court's ruling, whichever way the court would rule on the instant motion we just argued. So I'm open to suggestions of this court or counsel. Judge, I don't know if it's ripe until this court rules.
I think it's ripe. You've got section 3111(1)(c), and you've also got the case law.
Yes, Your Honor, and with that, I am asking for immediate release, and some of the same arguments we've already presented with regard to the Hague third report. Judge, this is on appeal. It's been remanded on a limited basis for this court to rule on the motion for new trial. I know that the state has responded that there are issues that Ms. Gutierrez-Reed has had with regard to statements she's made. But Your Honor, the fact of the matter is, while she was on pretrial release in this case, she didn't have any violations. She didn't go anywhere. She's not intending to flee. She's not intending to try to avoid prosecution. Your Honor, and I would submit that if, or to avoid her obligations to this court, I would submit that she's not a danger. If this court were to enact conditions, she doesn't have firearms. She could be on house arrest or whatever conditions this court deems appropriate. While this case is pending, whatever decision this court makes early next week, that she'd be allowed to be released pending the appeal. One of the problems, Your Honor, is that the length of time of this appeal, if this case proceeds to appeal, is likely to take longer than her sentence. And that's just a fact of how the system proceeds. And so we're asking, with the issues we've raised, for this court to consider releasing her while this court considers this motion and the appeals court considers our arguments.
Ms. Morrissey.
Your Honor, the state objects to the release of Ms. Gutierrez. Mr. Bowles indicated that she didn't have any violations of her conditions of release. I think we didn't have any evidence of those violations that we could bring to the court, but we did discover when listening to Ms. Gutierrez's jail calls that she was in possession of alcohol during the trial. Discussed violating the court's order that she not possess firearms during her jail calls. And she has already signed a guilty plea to a felony in her other case. So Mr. Bowles' argument that she doesn't have any other criminal history, I know that he argued that initially in his motion, and she has now since signed a guilty plea in that case. So I'm not trying to beat him up over that. When he made that assertion in his initial motion, it was accurate in terms of her convictions. It is no longer accurate. And based on those issues, we would ask the court to deny Mr. Bowles' request to release Ms. Gutierrez. And I will say that one of the things that has mystified me in terms of the way that Mr. Bowles is handling his appeal, he's filed more than one motion before Your Honor asking that the court release Ms. Gutierrez. I think this is the third such motion that I have responded to. I think the court has only heard two of them because one of them was never set for a hearing. But if Mr. Bowles has concerns about the fact that his appeal is going to take so long that essentially Ms. Gutierrez will have served her entire sentence by the time his appeal is over, I don't understand why he isn't addressing that with the Court of Appeals. I think that he can do that. I think that he should do that, and he should have already done it. So we would ask this court, based on everything that we've gone through this morning with regard to Ms. Gutierrez's motion for a new trial, the 6 factors that have to be met in order for that to be granted. I have never seen a case in the state of New Mexico where the district court dismissed a case post-conviction based on discovery issues, and I don't think that Mr. Bowles has pointed to such a case. So I don't know that asking the court to dismiss the case against Ms. Gutierrez based on the 2 issues that Mr. Bowles was unaware of during the trial is appropriate. The appropriate remedy is motion for new trial. He can't meet those 6 factors. So I remain confused as to if Mr. Bowles has concerns about the length of time of the appeal and how it relates to his client's sentence. File a motion asking for release before the Court of Appeals, because they have a better idea of how long their appeal is going to take than we do. But for some reason, he's not done that. So we would oppose Ms. Gutierrez's release. It sounds like the court's going to rule early next week. So certainly if the court rules that Ms. Gutierrez gets a new trial, the court can immediately release her. I'm not sure the court even needs to have a hearing on that. I think that's well within the court's power. But the state objects to it for the record. Thank you.
Your Honor, just briefly.
Reply.
Yes, Your Honor. Thank you. Just briefly. Your Honor, the reason why we are asking for dismissal in this case is that it is the most egregious case I have ever seen of prosecutorial misconduct. And there's always an instance where you have to ask a court for something you're compelled to do on behalf of your client, because there is no case I've ever seen that is this bad. Mr. Baldwin's lawyers wrote that in their response that they recently filed, and this court appropriately dismissed that case. That's why we have asked for the dismissal remedy, because this case is so egregious. What happened? Lying, cheating, hiding evidence. Second, Your Honor, with regard to the release, we wanted to go through the chain of command. We wanted to address that with this court first, and then we will, depending on this court's ruling, we would go to the Court of Appeals next. But I wanted to respect the chain of command and respect this court's authority over the proceedings, and that this court had previously ruled on those issues. So that's why we filed it. So, Your Honor, we would respectfully agree with Ms. Morrissey, if this court rules in our favor early next week, this court wouldn't have to have a hearing and could just release her.
All right, thank you, counsel. Again, I appreciate your presentations today, and I do appreciate your briefing. I'm going to consider your motions. I will address them in two separate orders. Your motion for release, immediate release under 5402, and then the order on discovery violations and inherent power, new trial and dismissal. All right. Thank you.
Thank you,
We
Your Honor.
are in recess.
Covering true crime and police arrest, where the judges move and the defense rests. Watching courts and trials, criminals at best, where the gavel drops and the defense rests. If you love true crime and you want the best, won't you find the time and the defense rests?